Adam Krupp, Director of DCS.
Dale Devon, State House Representative, District 5, St. Joe County, home of the Fighting Irish.
Corey George, Chief Probation Officer, Wayne County.
Terry Decker, Department of Correction, Division of Youth Services.
Julia Stomler, Youth Representative.
Eric Miller, Deputy Secretary, FSSA.
Justin Fortner, Chief Administrative Officer, Indiana Supreme Court.
Mark Fairchild, Executive Director, Children's Commission.
I am Dana Kenworthy from the Court of Appeals, and online we have, I see Bernice.
Good morning. Bernice Corley, I'm Executive Director of the Indiana Public Defender Council. Glad to be here.
And maybe Senator Donato.
Good morning. I'm Stacy Donato at Indiana Senate District 18.
Okay, and who else have we got online? That's it? All right. Because this is Child Abuse Prevention Month, we're going to start with some information from our new director, Director Krupp. So I will turn the floor over to him.
Thank you, Judge, and good morning, everybody. As you can see, I'm wearing a lot of blue today. It's not hard for me as a lifelong Kentucky Wildcats fan. There's a lot of blue in my wardrobe, but that's just a benefit for the cause this month. I've been wearing a lot of blue pants and people have been asking me questions about that, which is great because it gives me a reason to share. I tell people this is National Child Abuse Prevention Month, April every year. I said, but it should be every month. But the fact that we can shine a light on this issue and draw attention to it every April is wonderful. We had an event in the State House last week to really kick things off. The governor spoke, I spoke, our partnership with the villages, CareSource. I mean, it was just a wonderful event. I know there were a lot of legislators there too, standing room only crowd. And so just to see that many people there in support of the cause was really special. A couple of things I shared in my remarks that day. One thing, if we just look at numbers, I know we talk a lot about the number of reports to the hotline, but last year alone, there were over 100,000 cases that were assessed by the team at DCS. And so, that's over 100,000 opportunities to intervene in a situation, 100,000 opportunities to potentially heal, but also to prevent further harm. And so beyond that, I said, but it's not about numbers and it's not about data, it's about people. And so if we talk about over 100,000 situations that had to be assessed, those are children, and we can never lose sight of that. And so my call to action that day was that, we strengthen our families, we protect our children, and all of us, and I would include this group because that's really a great purpose for this gathering, that all of us help cultivate an Indiana where every child thrives. And no Hoosier child should live in fear. And it takes a village, it takes a community. We hear that all the time. And I said, so let's look around our communities and ask the question, what can I do? What can I do to support Child Abuse Prevention Month, not just in April, but in every month? And so there are events happening all over the state. I'm really excited about that. Before I got to DCS, I see the blue pinwheels, and candidly and transparently, I had no idea what they stood for. So I love that I now know that. And I love that I have an opportunity to tell so many people what it is and what it stands for. I'm wearing the shirt today with a pinwheel so that people can ask me, hey, what is that? I say, well, look at the back of my shirt and let's have a conversation. And I know Eric Miller, who's on this commission, knows all about it too. And so I thank him for being my predecessor and doing the work for several years at DCS. It's such an incredible job that our entire team and our agency has to do every day. And the stuff that our team sees is downright evil. And so anything we can do as a community statewide to fight child abuse, we should be doing. And I closed my remarks the other day by saying the best defense for child abuse is a strong family. And so if we can be mindful of that and strengthen our families within our communities and provide all the resources, then we'll be doing our part. So I'm going to go up to my hometown this week on Friday to plant pinwheels around the community at an event. And then I'm going to go to Vigo County next week and do the same thing. And if I do that every day this month to raise awareness and open eyes and minds and educate people on what a blue pinwheel is, then I feel like I've done my part and it'll be a successful month. So it'd be great if everybody on this commission could do the same thing in whatever small way possible, and everybody around the state to be good leaders, be servant leaders, and really do our best as a state to minimize, reduce, and someday put an end to child abuse. Thank you for the time. I appreciate the opportunity.
Thank you, Director Krupp. I want to tag on a little bit on some things that Director Krupp said, and that is that these are really tragic circumstances, and the people working these cases are experiencing these tragic circumstances. So I first want to remember all of those people in our system who are doing their very best to reach out and help these families and children get better in these very tragic circumstances. I also want to let you know that I've had an opportunity to travel around the nation and attend some national conferences on child-related policy recently. And what I'm learning and talking to people from other states is that this group, the Commission on Improving the Status of Children in Indiana, is unique. Unique in that, number one, it exists. Policymakers all around the table, child serving agencies coming together to collaborate to make things better statewide. And second, that we're active. Some states have groups like this, but they just don't meet. They're just not that active. And this is an incredibly active commission, many work groups doing a lot of great work. And so one of my favorite quotes is by Nelson Mandela, and that is that the true character of a society is revealed in how it treats its children. So I think Indiana is doing many good things, and Indiana has a lot of work to do. So with that, I will say let's get to work and move on with our agenda. You have the minutes from the February 2025 meeting. Are there any needed edits to those minutes? Hearing no edits, do I have a motion to approve? Do I have a second?
Second.
Okay, we have a motion and a second. Any discussion? All in favor say aye.
Aye.
Opposed, nay. Thank you, Bernice. All right, now we're going to move on to a presentation by Jamie Devine from Court Improvement Program. She's going to report on a number of listening sessions that judicial officers held with foster parents, biological parents, and youth involved in the system.
Good morning. Thank you. And thank you to Judge Kenworthy for having me here today. My name is Jamie Devine, and I'm the Court Improvement Program Administrator with the Indiana Office of Court Services. If you hadn't had a chance, we do have a one-pager out there with more information on our program, but I'll give you kind of a brief synopsis of what we do. We receive federal funding to carry out purposes to improve safety, permanency, and well-being outcomes for children and families involved in the child welfare system. And that includes assisting our courts in carrying out laws related to CHINS and TPR cases, enhancing collaboration between courts, DCS, and tribes, and increasing expertise in child welfare amongst our stakeholders and facilitating cross-training opportunities. Most importantly, in my personal opinion, we maintain a data dashboard that includes court performance measures related to timely permanency and child welfare outcomes. Please look at the one pager. There is a QR code that you can go to see that information. So what am I here to talk to you about today? I'm here to talk to you today about a series of listening sessions that took place recently between a panel of judges with expertise in child welfare law and lived experts. And we all heard Director Krupp just say, this is about the people and this is about working together. And he is absolutely right. And that is what the purpose of these sessions was. It is to bring together the people who are most affected by the child welfare system, including foster parents, birth parents, and youth themselves, and giving them a voice to have the opportunity to speak with judges with expertise in this area to have an open conversation and dialogue. This came as a directive from Chief Justice Rush. This past fall, she was present when foster parent representatives from Champions for Children were testifying at the legislature about their concerns with Indiana's child welfare system. And they said that they don't really feel heard in the courtroom. And that's very concerning to our courts and to Chief Justice Rush, because it is so important that we listen to the people that are most affected by the system and that we make the decisions about every single day. And so she directed CIP, Court Improvement Program. There's a lot of acronyms in child welfare, which I'm sure you all know by now, and the commission to work together and collaborate to invite them to the table to have that opportunity to speak to the judges. So the first thing that we did is say, who are our judges going to be? We immediately identified our wish list of superstar chins and TPR judges. Judge Kenworthy, who before her appointment to the Court of Appeals was a trial court judge in Grant County. Judge Stephen Galvin from Monroe County, Judge Heather Malo from Bartholomew County, and Judge Nancy Gettinger from LaPorte County. So we had representation from all across the state. And we immediately met and talked about, what do we want this to look like? It needed to be an open conversation. It was really important to our panel of judges that we were listening and actually hearing what the lived experts had to say. What are your concerns with the system for the courts, but also, you know, they did express concerns with some other parties too, which we'll talk about that. But really a conversation where they could be candid and the judges would have the opportunity to listen and also provide some feedback and explanation about things that came up. And we discussed that we wanted to identify systemic barriers. What are the big picture issues that we can kind of work together as a system to improve? Not really, talking about individual cases, but these systemic issues. I will say that the judges took some really difficult questions. A lot of really, really difficult and challenging topics came up, and we learned a lot from the sessions. So the first session that we held was with the foster parents and 2 representatives from Champions for Children. And if you're not aware, they are a group that advocates on behalf of the best interests of children in the foster care system in the state. This session took place in December 2024. All the sessions took place over Zoom, and that was at the request of the participants. We wanted to meet them where they were. That was really important. And so that those individuals who live in different areas of the state could conveniently attend the sessions. That's why we did it virtually rather than in person. So one of the, and you'll see I have here listed some general areas of concern, but lack of communication across the board. So it was pretty clear that there's not really training or education for foster parents on what does the legal system look like? What am I getting into? Not only when I take a child into my home in terms of being a foster parent, but there's that whole other piece of it that involves the court process. Who are all these other parties that we're interacting with? What are their roles and responsibilities? That was an area of confusion as well. What does the FCM do as opposed to the GAL or CASA? What is the judge's role as opposed to the DCS attorney's role? How do we all work together in this system? And what is happening at each juncture of the case in terms of you all know there's all these different kinds of review hearings and permanency hearings and initial hearings and all these things that are happening. And there's just a lack of communication to those foster parents about what does that process look like, which then creates confusion and misunderstanding. They expressed that their members across this state had very different experiences regarding how they were included in court hearings. Some expressed that they're not allowed to attend or speak at hearings at all. Some said they can come and stay for the entire hearing. Some said they're allowed to come at the beginning of the hearing and then asked to leave later. That was a concern because they have very important information about the child or children that are in their care's day-to-day life. And they do have certain statutory rights regarding presenting that information as well to the court. So that was an area of concern. They also expressed concerns that DCS does not always provide them notice of court hearings or copies of court reports when they're permitted to do so. And so they're not really keeping up to date on what is going on in the cases. And that also that at times when they do receive court reports from DCS, they contain misinformation or pertinent information is omitted, and that they don't feel that there's a way for them to correct that or bring that to the court's attention. They also expressed that sometimes when a DCS attorney will subpoena them for an important trial, such as a termination of parental rights, that that attorney does not contact them to prepare them for trial. And any of us who have been in the courtroom know it's I got nervous and I did it for 12 years until the last trial I did. So I can't even imagine how nervous you would be as a witness if you're going up on the witness stand and have not been prepared for that hearing. Delayed permanency is a topic that we all talk about all the time. Some issues that the foster parents believed were leading to delays in permanency included filing continuances, and it sort of became clear from the listening session that they weren't sure why continuances were being granted. And so it led to the perception and then a lot of times misunderstanding that there wasn't a good reason for that. And so something that we can talk about is, and the judges had the opportunity during the panel to explain, sometimes something happens, like for example, if it's a case where I need a Riley doctor and they get pulled into a procedure and they can't come, we may have to continue that so that that key witness is present. But since if we're not communicating that information, then they're not understanding why the hearing is being continued. There was also some frustration that parents being appointed counsel late in a case, for example, if they're not located until late in a case, if they're kind of MIA at the beginning, but then later on they appear, or they've had an attorney previously appointed who's withdrawn, and then the court reappoints counsel, that causes delays. So the judges had an opportunity to explain that they have certain due process rights regarding appointment of counsel. So those are just sort of some concerns. And then obviously the one we are all aware of, filing TPRs in a timely manner. As for child safety, there were concerns about allowing parenting time for parents who may be testing positive for certain substances. And the judicial officers were able to explain again that there are lots of things to consider when deciding whether to suspend parenting time, and that DCS does have ability to offer supervised parenting time, therapeutically supervised parenting time, ways to make sure that that child is safe, and also the kind of impact that suspension of parenting time may have on the child or the case. So just kind of that education about all of the factors that go into these decisions that they weren't aware of. And then in terms of holding parents accountable, as I said before, concerns about appointment of counsel later in the case, and then the courts holding parents accountable for failure to comply with their case plans in a timely fashion. So some recommendations that came out of this session. So I should add that after each listening session, the judges had an opportunity to debrief either by Zoom when possible, or, everyone has a busy schedule. So by email, if permitted, to kind of talk about what were the recommendations coming out of the sessions. I will note that we are all aware that there is pending legislation that may change some of these recommendations. And we have a team of people at our office that are monitoring that, and we will update accordingly, depending on how all of that plays out. But as I said earlier, one of CIP's roles is to provide cross-training for stakeholders. So something that we would love to discuss with DCS partnering with our networks, with the Public Defender Council, what can we do to provide different trainings for these groups that can kind of touch on some of these topics? So I actually did have a meeting with DCS, and as a part of the PIP, they're talking about revamping foster parent training. And we did discuss perhaps adding a session on this topic, on what does the case look like? Who are the parties? What are their roles and responsibilities? What are your rights as a foster parent? And perhaps even seeing if we can find a judicial officer to record it so that they don't, it'd be hard to get a judge to come to every single training, but just some kind of continuing education or initial education for the foster parents on that end. And hopefully to also incorporate in that training discussions about parenting time guidelines and other concerns that parents may have. For judges, it's really important that they expressed that they want to feel welcome in the courtroom, welcome to be there, welcome to speak, welcome to present information. Encouraging judges to explain what's happening and why, both on the record and in written form, especially with the continuances. That was kind of the big example, is this is why I'm doing this. Just taking that extra time to explain why we're doing this could alleviate some of these miscommunications and misunderstandings that are happening. And then for DCS, making sure that when they're permitted to do so statutorily, they're providing the foster parents with the documentation that they're permitted to receive regarding court reports, making sure they have input on how the case is going. And then overall as a system, working together to cultivate that sense of urgency to achieve timely permanency for children, while also balancing obviously the best interest of the child, which is what we're all here to do, and the specific needs of the family. I do know that stakeholder collaboration is a really big part of the state's program improvement plan, and both the Office of Judicial Administration and DCS leadership have issued directives to the judges and to DCS staff, encouraging them to, at the local level, come together and collaborate at stakeholder level to meet and discuss barriers to permanency in your own communities. So that is something that that we would really encourage. And again, my program is available to provide technical assistance to assist with data for any community that is interested in setting up these collaborative meetings at the local level. In February, the panel of judicial experts and lived experts of birth parent listening session took place. And this took place at the DCS Birth Parent Advisory Board's February meeting. Thankfully, our judges were willing to go after hours and meet them where they were, so we greatly appreciated that. So it was a lot of you'll kind of see these running themes, the same kind of lack of understanding of the system and the expectations. The birth parents really expressed a sort of a feeling that it was like everyone was against them, that things were happening to them, not really understanding that sort of almost a confusion that the courts and DCS kind of were working together and not really understanding whose role was what in the case. And a lot of confusion about services. Why am I ordered to do this service? How do I navigate this particular service? So, why, if I have my own provider in my own community that I have an established relationship with and that I can continue working with after my case is closed, why is DCS telling me, no, you have to use this new provider that I'm telling you have to use? Why can't I continue with that provider? So a lot of confusion and questions about that. And then the underlying current of this is really traumatic for parents when they're going through the system. I think we talk a lot about the trauma that affects the youth, but the parents are also really traumatized too. I think it's probably the worst day of your life if somebody comes and takes your child out of your care. At least it would be for me as a parent. And so just kind of recognizing that when you're in the courtroom and people are talking at you and speaking legalese, and we all have our little scripts that we're used to, that the parents may not know in that moment what is happening and why. They are concerned that they really express that they would like to have counsel. And I know that this is a big issue and I don't know, what's possible and funding and all of that, but they would really like counsel at the initial hearing. And that's for multiple reasons. They're concerned about potentially waiving important rights without having counsel. And also a lot of times at the initial hearing, it could also be a detention hearing. We're talking about removal or continued removal of a child, and also what that parent's parenting time would look like. And they would like to have an attorney representing them at that very critical juncture of the case.
They not get a public defender or just the child gets a public defender?
So they do get a court-appointed attorney, but a lot of times the court-appointed attorney is appointed at the initial hearing. So then they have that attorney later on in the case, but so many kind of critical decisions are made at that initial hearing. Like, for example, if your child is removed, that's going to set the tone for the case, right, going forward. And so what they were saying is, we would like to have an attorney if possible. And this, I'm just reporting the recommendations. I know we have somebody from the Public Defender Council, the executive director on there. And there's, I'm sure, a lot of barriers to that, but that is what they were reporting that they wanted, just to make sure that their rights were protected. As for DCS, the biggest issue was the services. Why am I having to do this service? This service actually going to help me, as opposed to like a checklist of cookie cutter services. They didn't understand the DCS policy. They said a lot of times the case managers will say, oh, that's policy, but they couldn't explain where the policy was. They couldn't explain what it meant. They couldn't explain why they're applying it in one way to this person as opposed to somebody else. And then one thing that kind of came up that was a little bit outside the scope, and I'm going to mention because we have Director Krupp here, is an issue with the child protection expungements that they brought to our attention. And they said that there's sort of this perception that there's a DCS policy to oppose all of those. And even if there's a circumstance where it's appropriate, and there was a DCS worker there who confirmed that there was a time where she supported a CPI expungement, but then her attorney told her, no, you have to object to it. And so that, I'm just bringing it to your attention because that was a concern. And really interestingly, since we talked to the foster parents as well, the birth parents really desire a better relationship with the foster parents. They want to collaborate with them. They want to have parenting time with the foster parent present, perhaps a mentorship type relationship. really to kind of get to know the foster parent and talk about the child. I mean, if we're here to talk about the child and these people are both important in that child's life, how can we work together to do what's best? It does take a village, right? So how do we encourage those relationships when appropriate and when in a child's best interest, and cultivate that rather than the sort of adversarial relationship that has existed up until this point in a lot of situations. Again, education and training, we talked about that. Really recognizing the trauma, so trauma-informed training, providing the opportunity for materials for birth parents about their rights and the court process, similar to what we discussed previously with foster parents. Also too, for the public defenders, and I'm so sorry I omitted this from the last slide, but they did say that the biggest issue with the public defenders was lack of communication, not being able to speak to their public defender until the day of the court hearing, not being able to get a hold of their public defender, not being confused about why certain information may be presented that they felt was inaccurate, or certain information wasn't presented that they wanted presented at the hearing. And also this feeling that who's going to hold DCS accountable when the focus seems to be on parents and parent compliance rather than a discussion of, well, if DCS isn't doing their part, who's holding them accountable? So that also was brought up. One of the practices that was really encouraged was when the parent has access to like a system navigator or social worker through the public defender agency, that was a really positive support for them, and they would like to see that expanded if at all possible. I already talked about PD access at an initial hearing if possible, meeting with their clients face to face, and then for DCS, really making sure that referrals are made in a timely manner, and that the referrals, and I know this is also part of the PIP, but that the referrals are targeted to address the identified safety concerns and to improve parental protective capacity, not just like a cookie cutter. Oh, you're a dad, so you have to go to father's engagement. Well, does that service actually going to benefit that person and their needs in terms of this child's safety and this parent's ability to safely parent that child? Let's see. And the other issue is we all know there's a lot of FCM turnover. So just having somebody familiar with that case so that if they do get a new FCM signed, there is that continuity and not kind of having to start over. So just maybe if there's a way to have an FCM supervisor step in or somebody that can like have the bridge that gap. And again, collaboration. I talked about possibly collaborating, finding a way to improve relationships between birth parents and foster parents when appropriate. And again, meeting together as a system to talk about these issues. We saved the best for last. And the last session we held was with our Youth with Lived Experience, and that just happened on March 28th. This was a partnership with Foster Success, and we had Youth with Lived Experience who were present. They were Indiana Youth Advisory Board members and lead ambassadors. They were so passionate, and I would say, Judge Kenworthy, I don't know if you agree with me, but I think they asked you all the most difficult questions of all. There were some tough questions. I felt very privileged to be a part of listening to that. They want to make sure that they're included in case decision-making. I mean, we're talking about their lives, right? At the end of the day, what we're doing is we're making decisions about these children's lives and their permanency. And they want a voice in that process. They want to make, not just in court, but also in the case planning and placement discussions as well. The court process itself can be very intimidating, and they want to make sure that we're doing what we can to make sure that it's a comfortable experience for them. A youth gave an example of going to court and her abusive parent was there and she didn't know, and how traumatizing that was. So again, we all know how traumatizing this experience is for youth, and we want to do what we can to minimize that for them. Inconsistent practices statewide, they called it justice by geography. For example, in one county, why would a family be able to have the child stay in the home of family preservation while in another that child's removed? So that was a concern. They were concerned about implicit bias and making sure we're all checking that. I know DCS is working on that as well as a part of the program improvement plan. And then just, like I said, a trauma-informed courtroom, supporting youth that are going to age out of care. And they also brought up holding DCS accountable and not knowing what to do if the caseworker wasn't doing what they felt they should be doing to provide the youth with their support and needs, and they weren't sure what they could do to address that. They also, and this is another point I have found really interesting, because we focus on time to permanency and we're always looking at the numbers and the numbers and the numbers. And I know why we have to do that, right? Like we have this federal guidance and all trickles down, but the youth said, it feels arbitrary. to me. You're talking about 50, what is this 15 out of 22? Why do we have to rush that, right? Like, what if my family needs more time than that? And it's just this unnecessary pressure. And for example, they said, well, what if a family ends up in a TPR proceeding when they shouldn't, because they just need a little bit more time, but we're so focused on these timelines that we're not taking into account what's in the best interest of the youth? Or the alternative could happen where we're so focused on the timeline that we rush reunification and it's wobbly and the family wasn't fully ready. And then it fails, it's a failed reunification and they end up right back where they are. So they had some concerns about the pressure of the timelines as opposed to, and how that can conflict sometimes with what's actually in the best interest of the youth we're helping. So again, lift up youth voices in a meaningful way, make sure they're included in case planning, encourage them to participate in court hearings in a manner that's most comfortable for them. Do they want to come to court? Great. How can we make that comfortable for them? Judge Kenworthy had some excellent examples of things that she did in her courtroom, like allowing the youth to sit with who they're most comfortable with, allowing them to take breaks if they need to do that, really getting to know them as people. That's so important to them. These are people, these are human beings, and it's not just another case. They talked really, really favorably about judges who remembered what activities they were involved in and asked about things that they were doing and what their future plans were, and really remembered what was going on in their lives. And that really stayed with them. If they don't feel comfortable coming to court, which is completely understandable, their FCM or their jail or CASA could provide a copy of a youth court report that they could file, with the caveat that it must be served on all parties. And then if for whatever reason they feel that there's something that they didn't get to say in court or something happened in court that they want to talk about later, perhaps give them the opportunity to fill out another court report form after court to provide the judge with another update. And then maybe that may spur the judge to set another hearing or another party to ask for him to address the youth's concerns. Clear communication, again, recognizing the trauma that the system has, making sure we're all checking our implicit biases, and just speaking in plain English. I think that that's kind of one of the things. I mean, I don't know, I did these cases, and really you can kind of get in your rote. You have your script. There's all these different Title IV words that you have to say and all of this legalese. And I think that for the lay people in the courtroom, it's confusing and they don't understand. So use plain English when we're explaining what we're doing and why we're doing it. Just explain why you're making your decisions regarding the youth, making sure that they know that they're heard. Do you have any questions? Do you understand? Is there anything that I can clarify for you? Just making sure that they're able to participate in those hearings. And then balancing the timely permanency, like we said, we need to have a sense of urgency on these cases. If we're really working the case early on the case, and front loading those services, meeting regularly, talking, making sure the case is moving forward, then we're balancing that sense of urgency for permanency while also keeping in mind the best interest of the child and the family is the paramount reason why we're here. And some of the tools that we can use for that, regular child and family team meetings and case planning sessions. If your jurisdiction permits permanent facilitations and mediations, those can be used throughout the case, not just at the fact finding or the TPR, but to keep cases on track and to talk about barriers and to check in on how things are doing. And really making sure that we're being aware of what services we're asking people to do. And that, again, that they're related to the safety needs and improving the parental protective capacity. So I think that I talked over my time and I forgot to turn my timer on, and that's why, and I'm sorry, that's my fault. But here are the key takeaways. You all heard me say it. Communicate, collaborate, and continue conversations. Does anybody have any questions for me or Judge Kenworthy?
I'll let you go first, Judge.
I just have a few wrap-up comments, so you go ahead with your question.
Well, I have one question and then several comments. My first question is there a thorough write-up containing data, specific quotes, comments that I can view from your sessions? Is there a report?
Yes, I have created reports for the Chief Justice. I will have to talk internally about, I'm sure I can adapt it for you. I do not have data because all of this was anecdotal, right?
Right.
So when we're talking to people, they're talking anecdotally anecdotally about their own experiences. If you do have specific data related questions, in addition to the CIP data dashboard, if you have anything specific that we could try to pull, please let me know and I can talk to our data analyst about that. And we can include any data that you're curious about or interested in. I think my contact information is on there. So please send me an email with specifically what it is that you would like us to pull, and we would be happy to do that.
Yeah, it's not so much data. I mean, I live in an anecdotal world and I've, to your point, I mean, I think I've had a cup of coffee with over 50 foster parents. And so that's what I do every day. So I just want to match what I'm hearing with some of the things you guys were hearing and collecting beyond the slides, but I obviously don't need names or anything like that. So some comments, because there was a lot there. I feel it would be silly for me to not say something. Plain language, that was, I think, one of the last points. So the Child Welfare Policy Manual for Indiana that DCS publishes and posts is over 1,600 pages, and I think that's ridiculous. So we are working on finding ways to reduce it. I had it, a friend of mine ran it through a real quick AI tool to show that the reading level is at a college level. So that alone tells me something. I know people don't like AI for certain reasons, but there's great value in it. For example, of running a 1,600-page manual through a tool, and it can tell you within seconds what reading level that document is. And so we are going to have a work group put together to analyze the policy manual for child welfare throughout Indiana. I think I printed it, right? Double-sided. It didn't fit in the binder, and I'm reading through it, and I mean, I'm writing in it, I'm making comments, and I'm saying, this is silly, this is stupid, why are we doing this? So, you know, that is years and decades of policy upon policy upon policy, to where at some point you've got to say, let's take a fresh look at this. So I think if we're going to improve the system, that policy manual that is this big has got to be analyzed. So that's one thing that we're doing at DCS. Communication, and my goodness, we're never going to do enough of it, but we need to do more. And that's a priority right now for us with how we communicate with foster families, biological parents, stakeholders, courts, everybody across the board. I mean, the things you're mentioning about some of the feedback from these sessions, I couldn't help but smile, because now I will say, and Eric knows this, DCS is in a no-win situation almost all the time, because the biological parents are mad at us. They think that we're conspiring against them. Foster parents are mad at us and think that we're conspiring against them. We're not, but you know, we need to get better at how we communicate, educate, and partner. I will say that I have preached to our staff, every office I've been to. You know, I close now with, you know, when was the last time we thanked our foster parents? I said, we need to put our arms around them and treat them like the true partners and teammates that they are. And that is no disrespect to a biological parent. But the system doesn't work without foster parents and foster families who are willing to open their private, personal homes to these children who need to be safe, whether that's a short-term basis, a long-term basis, a permanent basis. And so we have to do everything we can, not just to recruit more, but to retain our foster parents. And we're not doing that today. The numbers will show that. And so we're going to do everything we can, and we've already started to better the relationships with both biological parents and foster parents in Indiana. In terms of, there was a mention of FCM retention, continuity has an absolute direct measurable impact on permanency, the number of case managers, because you know, it's almost like the clock resets, because you have to start over with what is the case, what are the facts, what is the situation. And in some cases, you'll get a different FCM that has a different view of the situation. So that all goes back to culture. We are rebuilding our culture, started on day one on January 13th, and it's not complicated. The culture of DCS will be rooted and built in a foundation of servant leadership, compassion, and common sense. Those three things will drive everything we do every day. And the last thing I would say is that numbers and data and dashboards, and we've got lots of them.
Mm-hmm.
We have so many Tableau dashboards that I said I need a manual just to find the dashboards that we have available. So I am saying, you heard me say it already, I am saying it every day that we got to stop talking about caseloads and numbers and start talking about children and families. Otherwise, we are going to dehumanize what we do every day. So I just wanted to go on record and say, these are the things that are important to me. These are the things we are doing every day. It's going to take time, but the fact is we have already started on this journey. And I don't take it as, you know, personal attack or criticism. I like to hear what these listening sessions reveal, which is why that led to my question of, is there more beyond the slides? So-
Yes, and thank you for that, Director Krupp. I really appreciate that input. I do want to assure you that this is everybody's responsibility. This was not meant to be an attack on any one party or the other, right? And I think that we equally addressed all of the system stakeholders and concerns that they brought up with the public defender, with the judicial officers, and with DCS. It's not DCS's responsibility. It's all of our responsibility to come together. And we, as the courts, please reach out. We would love to collaborate. We're collaborating through the PIP. As you work through that policy manual, the Child Welfare Improvement Committee is made up of stakeholders from DCS, judges, public defender, GAL CASA. Please let us know if you would like to run that, come to one of our meetings and run the potential changes by us. We would be happy to provide some stakeholder input on that, because we really are all in this together. And to your comment about, you know, everybody feels like everybody's mad at you. I think everybody's mad at all of us. And I think that a lot of that has to do with the lack of understanding of the system, because it's kind of everything we do is done in the dark, right? And so, so we just have to get out there and make sure that we're doing training and explaining. And I'm so sorry, go ahead. I just want to say the courts are doing the same thing. We are talking about all of these updates at judicial trainings to judges. We are, Judge Kenworthy is going to be there at telling new juvenile judges about this information. So we're training them. And we're going to our judicial committees and sharing this information. So we're doing this as well. I'm so sorry, Representative Devon.
No, you're fine. I love your passion.
I'm Italian. I can't
And I
stop
just want
talking with
Adam
my
to know
hands.
that the legislator want to put you out of business too, so I don't want you to feel like we're leaving you out.
Please
So,
do.
but I have a question for the judge, because I've never been to a court hearing, right? So,
Sure.
and as legislators, when we look at legislation and we do some homework, right? So we're involved in the field, and then a bill gets drafted, and then we have first reading, the second reading, we have committee hearings, you've got public discussion and private discussion, caucus discussion. So by the time we get to the vote, about 95% of us have made up our mind how we're doing it. Is it that way in the courtroom too? So when they say people aren't listening, have you done your homework? So where you've already made your decision, but by the time the court hearing happens, when the people get to come and speak, if a child comes or a parent comes, have you already made your decision? You know what I mean? So they feel like they're not being heard.
I think what drives the lack of hearing is the lack of understanding to start. So first of all, parents, foster parents, children don't understand what's going to happen in this hearing and what opportunities they may have. I think that's the start of it. I think some counties do better at inviting feedback, inviting comments from all of the parties. My practice was everyone is invited, everyone is included, and we're going to give everybody an opportunity to speak. I don't think that happens in every county. Some of that may be driven by sheer volume. You know, when you have to meet these timelines for hearings and you have so many minutes in a day and no more, that's very difficult. But at the end of the day, I like what Director Krupp is saying, and that is these are not cases. I think when we get out of that mentality of these are cases, we start seeing the humans and remembering the humanity in that courtroom. And so the vast theme throughout these listening sessions was, I need to be heard. And so if you don't know that you're welcome to speak in a courtroom, you're not being heard. If your public defender's not explaining things in advance, if they're not explaining things in the process, you leave and you don't know what happened. We talked about initial hearings. At an initial hearing, immediately after the child has been removed from the home, this family is in turmoil. They're in chaos. Their brain is moving 1,000,000 miles a minute, and we're giving them their rights advisements while they're in this state of mind. And so we've talked about things like creating a video that's available online. Someone can go online and watch their rights at any moment in time. They can watch it in advance or after the fact and ask questions about it. So I want to speak a little bit to the foster parent angle. 2 of the 4 of us judges have been foster parents. So Judge Gettinger and I were foster parents in a previous life. And so we've seen things from both sides of the system. I was pretty much overwhelmed when I asked the question, what do you think about this move toward better communication between biological parents and foster parents? Both sides of that equation said, yes, please. They were so excited about that. And I think that's incredible. I think too many times the system gets in the way of that. So, you know, they feel like they can't talk to each other because there's some level of danger if they talk to each other. And that's just crazy. So I came out of these listening sessions very hopeful and really impressed by all of the people involved, because I think to a person, all of them had had a negative experience. They'd had mixed experiences, but at least one negative experience, and they're motivated to make things better. And they're doing it in a way that's collaborative and respectful. And so I am very encouraged by these listening sessions, and we've talked about doing more of them and doing multidisciplinary listening sessions, joining youth, foster parents, and birth parents in the same session. So Judge Galvin and I will be presenting this to the Juvenile Judges Conference in June. And the 3 other judges, Malo, Gettinger, and Galvin, are all what we call jurists in residence in Indiana. So they are senior judges, and they are available to all trial courts across the state. They can go and consult with individual jurisdictions on ideas on how to make things better. And I'll just say a little bit in defense of our judiciary, we have about 1/3 new judicial officers over the last 5 years. So we've got new folks, some judges who have never done a child welfare case before. So training has to be ongoing. Does that answer your question, Representative Vaughn? Probably more.
Helps.
I actually wanted to add on really quickly too, because as a lived expert, I went through the court system as a child. And I also am currently a visit supervisor for the court. And so I work with children, families, birth parents, and foster parents. And I really just wanted to say thank you, because I think you gave a very cohesive representation of what foster parents are saying, at least like in my ground floor work right now. And I think one of the most interesting things to me as, you know, a former foster youth going into these spaces is the wish for collaboration between foster parents and birth parents, and how many foster parents just want to be able to speak to the birth parents, or, you know, it's kind of, we have, at least, you know, for direction for us, a lot of times with DCS, there's such like a separation of, you know, that wall because of safety issues, because, you know, not everybody wants that collaborative relationship. But I constantly see that in my day-to-day work, where even like, you know, we're switching over the kiddo in between a supervision, and, you know, the foster parent wants to say hello, you know, the mother wants to, you know, just say thank you to the foster parent for serving their family. Like it's a very collaborative relationship. And then also, you know, as myself, I went through the court system. I think you really represented well the transparency that needs to occur. And I was very fortunate to have a judge that was very hands-on with me, that debriefed, a COSIP that debriefed with me. And then also just recognizing what you said, Devon, about almost it being so procedural. I see that every day. That was my case. It was, by the time we went to the courtroom, everything was already known. It was just for the record. And I think that is, to have that continue to be the case, there has to be that behind the scenes where all parties feel like they can communicate, including holding specific DCS and FCM workers accountable for families who don't feel like they have done their job, just because it is like the trajectory of their family's life, you know? So if you don't have a DCS worker that you feel has communicated, has checked in, has adequate information, has responded to simple calls and texts, like your family's trajectory is changed forever because of that. And there should be accountability in those circumstances. And I know I currently, as a visit supervisor, I see that constantly, where families are like, where do we go? Who do we talk to? From both foster parents and birth parents and children. So I just wanted to say thank you, though. I think that was a very cohesive presentation.
Thank you so much for sharing your experience and for being here today. And your example about that family collaborating. When I was in practice, I saw it too very few times, but when that foster parent and that birth parent were able to develop that relationship, I saw a case where that family reunified and that foster parent still provided childcare for that family. They became a part of that,
Yeah.
that system. And to your other point as well, and those ongoing conversations, the work that happens behind the scenes in between court hearings is critical, right? Like that's where the case is happening. The court only sees the case every 3 to 6 months or so. And all of the work is going on in the interim between the stakeholders that are involved on that individual case. And so again, if you have the opportunity to have a mediation or permanency facilitation program, it can be so invaluable to help those cases moving along and making sure that if there are those kinds of barriers that you're probably getting complaints about, it's because there's not really a valve to address them unless you're back in court in 3 or 6 months. And so thank you so much for that input. And that's definitely something that I think that we as a system can continue the conversations about how can we work through those barriers.
Yeah.
All right. Thank you, Jamie.
Thank
Excellent.
you
Excellent
so
work.
much, Judge Kenworthy. Thank you so much. I'm so sorry I went over my time.
Do we have any other, did I hear a comment?
Yes, this is Bernice Corley, Judge. May I have a comment?
Sure.
So first, I want to thank the Supreme Court for their leadership in this space. This is, that was really a fantastic presentation, as well as just starting those conversations. I think starting those conversations, continuing them, really is a great step in making the system better and outcomes better for children and families. And it just seems like a common sense approach that can help take the temperature down in this space. So I want to thank the court for that leadership and everybody that participated. I appreciate the council being engaged in the conversations as well. I do want to just say, in terms of going forward, the council is happy to be a partner and participate in doing whatever we can to improve trainings on our end for public defenders who do this work, helping families. So just see us as a partner. We're happy to engage. I did hear the question or comment around access to counsel at initial hearings. We wholeheartedly agree. The council for a long time has been advocating for more resources in public defense to provide that initial hearing representation. I want to say, remind everybody, every court in every county is very different. And what Representative Devon might see in his court in a county that has a public defender office may be very different from what any of you might see in other counties that do not. So standardizing resources so every county, as much as possible, has what they need to provide the supports possible. We are very much on board with that. And I definitely take the comment around need for increased communication with public defenders. And that is something that we continue to engage with our membership about, but not to make any excuses. Many of our public defenders are doing this work as part of a private practice, because they have a contract and they don't have a full-time devotion to this space. And sometimes it can be very challenging to negotiate it all, but client-centered representation is something that the council believes in, and we stress with our members and press for that excellence in all spaces. So thank you for the report. Thank you for the conversation and leadership, and we look forward to being part of it.
Thank you so much. I greatly appreciate it. Please feel free to reach out to me anytime, or I can reach out to you to discuss collaborating on trainings. I would love to do that. Thank you again.
Thank you, Jamie. All right. Next up, we're going to talk about chronic absenteeism and engaging people with disabilities. So we have a CISC fellow, Peyton Bowling, with us today, who will give her presentation.
Hello, everybody. Thanks to Mark and Blaine for letting me present. I have been looking into this particular issue in relation to how it affects people with disabilities for a few months now, and I wanted to share what I've found with all of you. first, I'm going to give you all a brief overview about what chronic absenteeism is, why it's important, and what causes it. Then we'll look at the unique needs that people with disabilities have in regards to attendance. Third, there's going to be some recommendations for how to address it. And then lastly, I'll connect that back to the importance of including people with disabilities in all decisions that are being made. And also talk about some of the efforts that the commission is making right now to increase disability representation in its task forces and processes. So, why is attendance important? It's pretty obvious to a lot of people. We've talked about it in this space before, but chronic absence is defined as a child missing 10% or more of the school year. So that would be 18 or more days where that kid is absent. And chronic absence means that a kid is less likely to read by 3rd grade, be college ready, and even graduate high school. So pretty important issue. As for where we are right now in the state of Indiana, as you can see from that graph there, maybe it's a little small, but the start of that graph is the year 2019 to 2020. And as we during the pandemic, when that started, the chronic absenteeism rate skyrocketed as school had to be remote. And then attendance didn't go back to where it was. It's slowly been getting better. But right now, as of the 2023 to 2024 school year, about 17.8% of kids in Indiana were chronically absent that year. And for our African American kids, that was 28.5% of them are chronically absent. So there's definitely a disparity. And kindergarten and also 9th through 12th grade are have the highest rates of chronic absence, especially 12th grade. That last year of high school is a big one. Who is missing school? It's 3 main populations, kids living in poverty, kids who are in communities of color, and kids with disabilities. So what are the barriers? There's a lot of them. They're in the slides. You can comb through them later if you're interested in doing so. I've listed the sources on the bottom of the slide. Right now, I'm just going to run through them real quick. Housing insecurity, food insecurity, lack of clean clothes, transportation, caretaking towards siblings or parents, a lack of engagement in school, bullying, physical health, mental health, immigration enforcement even, and also punitive discipline practices. So a lot of things that can factor into a kid not going to school. So obviously there's not going to be one cure-all miracle solution either. Now I'm going to get into why kids with disabilities might miss school and what the statistics are there. So about 15% of students in the US have a disability. That'd be 7.5 million kids, a big number of people. And US high school students with disabilities are 1.4 times as likely to be chronically absent compared to those without disabilities. Especially students with emotional disabilities, that's where we get the highest rates of absence. And in the school year of 2013 to 2014, only Native American and Native Hawaiian / Pacific Islander students had higher chronic absence than students with disabilities. So that's another population that where a lot of kids are struggling to go to school, and there are disparities. Now you might wonder why I'm citing data from 2013 to 2014, and the answer to that is that I couldn't find more recent data than that, and I could not find Indiana specific data for that particular statistic either. I this is something that's pretty common. Disability statistics are lacking for many different issues, and things that I've looked into with incarceration before, rates of disabilities or experiences of people with disabilities are, there's not really very many studies on it. So that that's something that should be a priority along with our others, because if we want to improve attendance, this is a population that can't be overlooked. And if we don't have the data, then we won't know as well what to do about it. So,
Hayden, did you check with anybody with the DOE?
I did, I assume they have that data, and I've asked a couple of people, but I don't think I was able to get back in touch with them to sort that out by the time I gave this presentation. I'm sure they do have that data, but I also think that that should be, you know, more publicly accessible and able to find if somebody's searching for it. But thank you. Now, absence by disability type also varies. Different disabilities affect people differently. And say two students who are autistic, two students who have autism, those kids won't be the same or face the same challenges. So it's a very multifaceted category, and thinking about students with disabilities in general might overshadow that, you know, every kid is going to have different needs. The main barriers for attendance for students with disabilities appear to be bullying, higher discipline rates, especially for out-of-school suspensions, medical challenges, and also lack of staff. So with bullying, this pie chart here, the blue portions are students without disabilities, and the yellow and purple portions are students who have disabilities and are getting accommodations. And the rightmost pie chart is students who have reported being bullied on the basis of disability. So you'll notice that despite the blue part being supposedly students without disabilities, half of them are who said that they've been bullied before on the basis of disability. So this highlights the fact that not every kid who has a disability are going to be receiving accommodations. And since a lot of the times the way we measure the number of kids with disabilities in schools is by those who are formally receiving accommodations, this serves as a reminder that there may be some blind spots in the way that we collect data at times. And it also shows bullying is relevant because that can lead to school refusal. A kid might not want to go to school because they're frightened that they're going to be bullied. It also increases suicide risk. So our very own suicide prevention, bullying, and social media safety task force, let's see if I said that right, should have the input of people with disabilities too, or parents of children who have disabilities, because they will have some insights on that, I'm sure. For discipline and out-of-school suspensions, this I was able to get recent data for. The number of Indiana students who have had at least one out-of-school suspension in that year from between the year 2013 to 14 and 2020 to 2021, the total of number of students getting suspended dropped, and probably a lot of that was because of the COVID lockdown. But between that time, Indiana also had a push to improve its disciplinary structure in a lot of schools, so that probably had an impact too. And you'll see that the percentage of those students who had disabilities is 28% and then 31% in both of those years. Now, if you'll recall, the percentage of students with disabilities in the US is about 15%. So that number is twice as high as it should be. The school to prison pipeline is also a thing. Children with disabilities are 400% more likely to be arrested in elementary school in the US, which getting arrested in elementary school is a big deal. And 25% of incarcerated adults have a cognitive disability in the US, compared to about 5% of adults have a cognitive disability just in the general population. So there are disparities there, and disciplinary systems can present not only attendance challenges, because out of school suspension counts as an absence for the purpose of chronic absenteeism. It can also prevent our children from success. Now we get into the topic of medical challenges. I'm going to present a scenario to you all now that I want you to imagine in your heads. I had a classmate in high school who got mono, Epstein-Barr virus, and they were absent for a few weeks. They had to catch up on homework for weeks after that. But not only that, they had lingering immune system challenges. They started getting sick all the time. I believe they started having chronic pain that wasn't easily explainable. They had all sorts of stuff that that my friend was dealing with. And I want you all to think of if this was your classmate, and they were, in high school, what would they have done? Would they have been able to, they would have worked out with the teachers? Would they have been able to get accommodations? In my experience, my friend, they had to talk to each of their teachers individually, and some were very helpful and stuff, some were very strict, but everything had to be worked out individually. Are pathways for these sort of medium-term attendance challenges, but they're not necessarily well-known or used or functional. There's something called a Certificate of Child's Incapacity that is in Indiana code. It's sort of like a more long-term doctor's note that doesn't have a limit on absences. But not all schools really mention that in their attendance policy. For example, I went to the webpage of Indianapolis Public Schools on their attendance policy for sick days and excused, unexcused absences. They had a lot of really helpful resources and links and explained things well, but they didn't have anything about the Certificate of Child's Incapacity. So giving more consideration to those students might improve that. There's also the fact that details about what counts as an excused absence and how many you're allowed to have are different for each school district, which can be a lot to figure out for parents and students. Things like how many absences can be called in by parents before you have to have a doctor's note. So there's that too. There's also long-term medical challenges. And it may be a good idea to look into what helps students who have the common accommodations that are used, and for kids who have chronic medical conditions, how many of them are actually getting access to the IDEA/504 plans? Are they typically accessing formal accommodations? as well as if schools have written policies for absence due to long-term health conditions. This is something that I talked to some parents of students with disabilities about. They shared their experiences and points of view that they had from their kids who have disabilities. And they were able to reframe questions around attendance in a way that I never would have thought of. But I'm going to share that with you. Sometimes a kid might, if a kid's absent from school, there's not really any way to fix that because they might be absent because they're getting medical procedures done, they're going to therapies, they're at doctor's appointments, for example. So if that child's missing school for that reason, that's not really an attendance barrier per se. They're supposed to be there. They're supposed to be at the doctor getting the care they need. So rather than just assuming that kids are going to be able to attend more, perhaps asking what isn't happening when this child doesn't attend. What are they missing that maybe they need? And if a student is going to be more absent anyway, no matter what, how are we as a state and how are individual schools ensuring that they're able to get what they need to get caught up and to be able to keep pace? So that's a very valuable thing to bring up. I think that would have never been on here if I hadn't spoken with people who are very eager to share. I'm going to skip a few of these in the interest of time, but another barrier is school budgets, low pay, shortages, and turnover, sort of lots of closely related issues that I'm bundling together. Staff turnover for both teachers and special ed staff can hurt attendance. Positive relationships with adults can increase school engagement, and when teachers are constantly changing, that can be hampered. Sometimes fast food and retail pay higher in Indiana than teachers and support staff, which is, it's like the most challenging and crucial support jobs sometimes get paid the least. So that's a lot of drain on the number of teachers we have. Special ed shortages impact the whole classroom because the teachers only have so much time to allocate to each kid. So the proper support for the higher needs kids is important. And support staff shortages can and do result in IEP violations. There was a case in Indiana a few years back where a kid with certain medical needs was left unable to go to school when the school district's nurse that they employed, who worked one-on-one with them, left, and they either could not or did not find the room in the school budget to hire another one. So he was left unable to attend school for several months, and there was a lawsuit. Special ed teacher turnover, more about that. There is some teacher pipeline funding that was partly funded through the COVID emergency relief that I believe last I heard IDOE plans to continue advocate for that those teacher pipeline funding programs. But there needs to be a living wage for the teachers too, because we'll need teachers want to stay teachers without that. I believe there is some legislation right now. I don't remember if it's passed already or not, that is increasing the minimum pay for teachers. And also ensuring that with the growth of private and charter vouchers and school choice and charter schools getting bigger, ensuring that public schools are still adequately funded, because they serve a lot of kids. Recommendations and possible solutions. I'm going to go a little bit more quickly through this section, but there's a few main things that boost attendance: engagement, positive relationships, a feeling of safety, and having basic needs met. The interim study committee on education met during the fall, and they did 5 recommendations, most of which I believe have been incorporated into some bills this session in some way or another, having to do with the Department of Education clarifying the categorization of excused and unexcused absences, basis or reasoning for student suspensions, and expulsions. Yeah. Some recommendations that I've seen in regards to students with disabilities are that state leaders should work to ensure that attendance policies don't unintentionally harm students with disabilities. And there's that, you know, listening to people with lived experiences thing again, where it might not be intentional, but you can do harm on accident if you don't include the people who the decision's being made about. And then when investigating excessive absences, considering if there's possibly a need for accommodations. And then also vice versa when during IEP and 504 meetings, considering asking, is there anything that we might be able to do here to help support this kid's attendance? I just think kids get the extra support that they need. Now, Senate Bill 282 passed last session, and it was, it included attendance conferences for students who have missed 5 or more days. I believe that there's a bill somewhere in legislation that's changing that to 10 days of absence. There would be an attendance conference with the students' parents, teacher, and a couple of other staff to look at how can attendance improve. I found this very interesting because attendance conferences like that are a part of recommended best practice strategies. But their current incarnation in legislation doesn't really allow for that. Every time there'd be an attendance conference, the school would, you know, hear what barriers a student is facing. And if having a lot of those and there's hearing the same issues over and over again, the current legislation by itself as it is doesn't really give any impetus for those individual conferences to feed back into learning better about how to support students on a wider scale. So it is a little bit of a more reactive thing, which is not what we might want in schools because the staff and teachers already have to contend with a lot of time demands on their day. So there is this model that's used widely. I know Project Aware in Indiana used it for mental health and it worked quite well, but it's called multi-tiered system of supports. So it's basically the concept is that about 80% of students can be served by just universal things that are already baked into the way a school does things. And then a smaller group of kids might have more targeted interventions. And then the smallest slice who still needs more help can get intensive individual interventions. So going back here, the model of Senate Bill, the model of the attendance conferences that a kid gets them when they're 5 days absent or 10 days absent in a year, and there's not really any other steps before that. They're a good thing certainly, but they can feed into what is going on that we can maybe make, you know, solve as a more fundamental part of the way we do things every day. And part of that can be using our existing data resources. I know that one of the interim study committee's recommendations was for greater use and study of the early warning dashboard. That's a little bit of a new thing. The pilot of it began in September, and I don't know quite where that is in April, but its purpose is for schools to help identify students who are at risk of not graduating early on so that they can intervene. And attendance is one of the markers that are used. So that could be used to identify patterns for possible tier 1 and 2 interventions, so that our schools can address attendance without, without just the attendance conferences as the only thing they use and feel like they're playing catch up. There's also the attendance insights dashboard, which is very helpful, and policymakers can see what districts and schools are most in need and see statewide trends too. That actually needs disability data to be displayed on there. It's the only one of the 4 demographics from the Every Student Succeeds Act accountability system that the Department of Education is already required to collect for federal reasons anyway, that is missing from that particular dashboard. All the other 3 demographics are there, and it could be, we know that they have this, it could be added. So I am planning on talking to them about that anyway. Yeah, this doesn't have to be like through amended legislation. It can be done in different ways too. My time is almost up, I believe, till questions, but I'm gonna go through pending legislation right now. Senate Bill 482 by Senator Donato, and House Bill 1201 or 1201, address attendance, and some other things. It would make the attendance conference be after 10 missed days instead of 5, and for all grades, K through 12, instead of just K through 6, which is important because 12th grade has the highest rate of absence. Department of Education must also establish a clear categorization for whether absences are excused or unexcused, and schools have to follow it. That would help students with disabilities and their parents because it would cut down on a lot of the ambiguity. And then lastly, public schools can't suspend kindergarten through 8th grade students solely for absence or truancy, which makes sense because it doesn't make much sense to say, we're going to kick you out of school or not let you come to school today because you haven't been going to school. There's some minor differences between the two, but the commission is supporting Senate Bill 482, and that actually just passed this morning. And then Senate Bill 409, employee absence for certain meetings. That says that employers can't take adverse action against employees for attending a child's attendance conference. And that's pretty important because that'll make the difference of whether the parents are able to come to the how can we help your kid meeting. And it's worth noting that if this passes with language that indicates general school meetings rather than just attendance conferences, it could apply to IEP meetings as well. I haven't looked at the language once since I read the slides, but that is worth noting and maybe even considering for the future. And then some complementary legislation, our own House Bill 1098, the Youth, Family, and Caregiver Engagement Initiative. Mark's going to be talking about that in a little bit. But basically, it would give us an opportunity to use it to also include the voices of children with disabilities, youth with disabilities who've had experience in the school system, parents whose kids have disabilities in decision-making processes. And there's also the House Bill 1285 that says that schools cannot prevent parents from recording IEP meetings, and that each school building must have at least one employee present who's trained in nonviolent crisis intervention. I mean, these both sound like good ideas on a basic level anyway. But what interested me about this was when I was watching the hearing on it, multiple parents showed up to that bill testifying about hoping that it could address bullying. So having another staff person there, and bullying, that makes sense. So, it seemed to me that parents of kids with disabilities, bullying has been an especially big concern for them. So that's worth thinking about as well. Now lastly, considerations for the commission on integrating youth and family voices. We've been working on this in general for years, as you guys all know. But in terms of commission engagement for people with disabilities specifically, we've been doing an email push to a few organizations over the last few weeks, inviting them, saying if you have any professionals or also any young people who you serve who would be interested in the sort of things that are going on in the commission, we would love to have, love to connect with you, meet with you, see if there's anything you want to contribute to. There's a few different ways. There's youth representatives, professionals can engage as task force members, and then there's more diffuse ways to engage as well. Given that we have the 2025 strategic plan writing coming up, we can also utilize language in that, something that, something about including the voices of people in each population. But we've been talking about doing that as well. But the big thing is that it's important to consider the needs of all populations who might be affected when we're working on issues that affect Hoosier kids. And I mean, the last consideration with that is that having a disability can take up a lot of energy and time. So yeah, I see some of you nodding your heads there. But so the burden of reaching out, is part of that, I think, should be on the commission. So that's what we've been doing. Yeah, that's all mine. Any questions?
Peyton, clearly you put in a lot of energy and time in this presentation, so
Thank
very
you.
much appreciate it.
Yeah, hopefully people found things interesting and it wasn't an information dump. But yeah, I think there's a lot of things there to be dug into.
We can see why you were selected as a fellow, Peyton, so thank you.
Thank you.
You're welcome. All right, we'll move on to Miss Alyssa.
Thank you, Judge Kenworthy. Good morning, everybody. In the interest of time, I get to talk faster, and I've been practicing talking slow, so now I can actually talk like myself during this presentation. Also, forgive me for referencing my sheet right here so much. I promised Blaine and Mark that I wouldn't yammer too much. And so in the interest of keeping that promise, I'm going to read from this. No promises around the 10-minute mark, though. I might start yammering. Again, good morning. My name is Alyssa, and I'm thrilled to be here today to share with you a bit about myself, my fellowship, and the exciting work we've been doing around youth, family, and caregiver engagement with the Commission. So a little bit about me. I graduated with my bachelor's in social work from Ball State University and will be graduating next month with my master's in social work from Indiana University, Indianapolis. Thank you. Thank you, Representative Summers. And so alongside my studies, I also work at Recovery Cafe Indy, where I have the privilege of providing social support to individuals in recovery. We truly believe that everyone is recovering from something. It's just whatever's keeping you from your best and truest self. I could go on about this job forever, but I will spare everyone. Enough about me. So, youth, family, and caregiver engagement. So over the course of my time here at the commission, I've had the chance to focus deeply on youth engagement and voice. Peyton and I each took a focus when we came on as fellows, her more focusing on, of course, chronic absenteeism, disability rights, and kind of the policy side of things. And I took the focus of engagement. Of course, there's been crossover in the work that we do, but it's been a true team effort that has shaped the direction of our shared fellowship and goals. As many of you know, CISC has been committed to increasing youth representation in our task forces, committees, and overall practices. I'm gonna skip over some of the history that I was gonna talk about because you all know it. I will also be saying we as if I had a part in what the commission has been doing for the past decade plus. So I want to talk about the incredible work that Adriana, a summer intern at CISC, did. She contributed a lot during her time at the commission. She focused on developing a model for our youth engagement efforts. So she asked important questions like, how can we ensure that our engagement efforts are equitable, efficient, and sustainable for what we're doing? Her work was really major and instrumental in helping us understand the current state of youth empowerment in Indiana. She conducted a literature review on different youth advisory boards in the state. She did a community assessment by connecting with and meeting with different organizations that elevate youth experiences and have established youth advisory boards. Through her conversation, she developed recommendations and next steps for implementing a more structured and informed youth, family, and caregiver engagement piece. Her work laid the foundation for a collaborative approach to youth engagement, one that I was able to get a kickstart on last August. As many of you may have connected with me during my fellowship, you know about this Excel sheet that I've been pouring my life into. One of the areas I've been focused on is the development of an advisory group list, one that I inherited from Adriana. She got it started and have built from. This is a space we're cultivating for greater collaboration and information sharing among youth advocacy groups throughout the state. We have seen that youth advocacy groups are doing incredible work at the local level, but many of these groups don't have the capacity to collaborate with each other in a meaningful way. This lack of collaboration results in a few key issues, like local data isn't shared widely among everyone, youth perspectives on policies are often unknown to the broader community, and similar work is being duplicated repeatedly. Our vision for this engagement piece is to create a space where youth-led advocacy organizations can expand their networks, share resources, and collaborate over shared initiatives. This will allow for a more efficient, unified approach to addressing the needs of youth across Indiana. Adjacent to this work is that of Thriving Families, Safer Children. CISC has recently joined their Learning Action Network, which focuses on bringing together stakeholders to achieve improvement through collaboration and shared knowledge. The results of this are to have increased understanding of the role of youth engagement and increased authentic youth engagement present in different participating sites. There's a couple of states that are involved in this. This has allowed us to consider this piece more broadly. I'm going to jump ahead actually, because I feel like this really kind of ties in with this a bit. Something else that Peyton and I focused on was program evaluation. We're taking a program evaluation class for our masters. And so we got to look at different children's cabinets around the nation, and kind of like Judge Kenworthy mentioned, nobody's really doing it like CISC. Nobody meets as much and as frequently as the commission does. The governance and size and activities of the different cabinets around the nation, they just function completely differently. And the fact that we work with all three branches of the government is really amazing and not common. And so now I'll jump back. Okay. Event tabling and planning. I got to plan a lot of our events with Blaine this past year, and it was really awesome, really fun. So more specifically, we had our fall virtual summit that happened in the fall. And so it was a 3-part webinar series focusing on the power of storytelling and strategies for harnessing stories to drive meaningful and powerful change. This really helped us lean to our planning for Day of the Child as well. In our day 2 of Day of the Child, our Strategic Sharing Academy. This featured a series of workshops focused on strategic sharing, of course, mental health, gun violence, and uplifting young leaders for change. That day, actually, we had a little bit of a switch and it ended up working out really well. We had the adults and the youth in the same room, and it was really awesome to kind of see them like engage with each other and ask really important questions. So that was not something we were expecting, but it worked out really, really well. 1098. Peyton spoke about 1098. Mark's going to talk about 1098. So I'm going to skip over it, but it's amazing. This is just a quick refresh on our different task forces. Our task forces are, of course, there to address the goals and objectives outlined in our strategic plan. We recently added the suicide prevention, bullying, and online safety task force. I was really excited to be a part of meeting all of the people that wanted to be on that task force, kind of narrowing it down, referring people to like other parts of the commission because they weren't the best fit for that, but they were the best fit for something else. So that was something that I was really excited to be a part of. I loved helping with that. And then I just really wanted to show off my handy dandy, amazing, wonderful infographics that I love to create in my downtime at CISC. Blaine calls me the interior designer of CISC, and I don't know what that means, but I'm really happy about it. And I love just creating things like this. So there's a one-pager that I created as well, just kind of making it prettier than the other one.
Does Blaine cause a lot of problems?
Mark causes more problems than Blaine, but both of them, yeah. Please don't work with them. Don't do it. Don't do it. Yeah, pretty awful. So what's next? Obviously, any sort of thing that I would look forward to or push anyone in the direction of has to do with youth, family, and caregiver engagement. Shocker, surprise, surprise. This is not a space where one agency determines objectives for groups to work on. It's a space where organizations can share focus areas, populations, recent work, qualitative community data findings, yada, yada, yada. From there, the group as a whole can determine next steps. Some groups may choose to collaborate on events, connect specific youth within their network, or connect over shared objectives. The collaborative should be administratively supported by the commission. Something that Blaine has always said to me is like, we don't own anything. We don't hold anything specifically to us. It's for other people to collaborate on, bring themselves to, and talk to others. But I think that CISC would be an amazing place to provide like meeting spaces and timeframes and kind of like the director of things, even though we're not really owning it. The commission, by virtue of its unique position and connection with each of the state systems to initiate information sharing relevant to the practice of state agencies, should provide updates on statewide initiatives and state system specific developments for the groups within the collaborative to connect over as needed. That's just a fancier way of saying what I said before. Some final thoughts. So I wanted to share a few things that I've learned, most of which Mark has said to me in like supervision meetings and such. So I just have a little like bullet point list. So building the muscle of open-mindedness. We can't really get a lot done unless we approach things with an open mind and see different perspectives. Assuming positive intent, I know for myself, sometimes that is hard to do, especially with the work that we do, but assuming positive intent of anyone who tries to take legislative action or propose a solution to something, just assuming that they have positive intent with what they're doing. What are we doing to repair the trust with communities that have experienced harm? Trust building never ends. This is really important because we can't fix people. People don't need to be fixed. They're whole human beings as they are. And it's important for us to repair the trust that maybe has been broken with them by others. And lastly, keeping in mind that sometimes we cannot be better than the systems people are already in, and that's okay. There's no blueprint for all of this. This is the first time we're all doing this. And yeah. In conclusion, the work we're doing through youth family caregiver engagement is just the beginning, but the future is incredibly promising. Through collaboration, intentional resource sharing, and dedicated staff, we're creating an environment where youth and families have a voice in shaping the policies that affect them. We're setting the stage for a more inclusive, youth-centered system of advocacy that will not only benefit Indiana's youth, but serve as a model for other states. Thank you for your time, your support, and your dedication to making a real difference in the lives of young people. I'm looking forward to what we can all achieve together. Thank you. Any questions?
Representative
Yes.
Summers.
When are you complete now, or are you still in your master's?
I'm pretending like I'm done, but I have about 3 weeks left here and with SACE. Yeah.
My son's case.
Am I really?
He graduates this May.
Who's your son?
Trent Barnes.
I love Trent. I went to Ball State with him. We were classmates at Ball State.
Yeah,
I
that's
love
my
Trent.
Dang, I'm so excited.
Oh, he did like the accelerated too, because he was already ahead by the
Right.
time that I started. So
Right.
that's awesome. Thank you for sharing. Anyone else?
Excellent work, Alyssa.
Thank you.
Thank
Thanks,
you.
guys.
Congratulations.
Thank you.
All right. Next up, Mark is going to report to us on legislative action.
Right. And I'll report while seating since I have far too much paper and tabs open and stuff to get up there with it. But I'll take this and relatively briefly and just giving you an update on some of our key pieces that we're working on. So our fellows have done a great job mentioning House Bill 1098 a few dozen times. So note that it's still alive and well. We have an appropriations hearing tomorrow. That is that overarching youth and family and caregiver engagement initiative that you heard a lot of the points related to, continuing to expand our work there, developing a state plan in that space, and looking what we can further there. So main change that you may not have seen yet is we did add an amendment in the Senate committee system, really just clarifying some of the specifics of what that would entail. So we did add that through that initiative, we'll also solicit the direct feedback from youth families and caregivers to inform commission recommendations on issues such as system complexity and inefficiency, duplication of services and points of consolidation, improving time to permanency, and reducing the negative impacts of system involvement. And you can see a lot of what Jamie shared really talks about how we would be doing some of that and expanding those types of listening sessions, and just making sure we really have an open ear and an unfiltered ear to what people have to say about what's working and what's not working. So pretty good amendment to pick up to just really reiterate that part of what we're doing. So again, appropriations tomorrow, right along with the budget bill and all the other last minute items. So we'll see how the last minute scramble ends up there. The budget bill still does contain funding for an additional position that we'd be bringing in to specifically be over this initiative, because we think it really deserves that kind of direct attention and not splitting 3 or 4 people's attention to try to get there and make sure that they're being heard. So we'll have more updates for you on that one at the next meeting. House Bill 1403, Juvenile Justice Matters. This is the next phase of the Youth Justice Oversight Committee. That has passed through both the House and Senate. So We'll see if there's any last minute conferring going back and forth. We're not anticipating that. That moved through intact. And that just really looks at shifting that YJOC from the body that created the initial reports and recommendations that led to some large grant funds that we're working with the Indiana Criminal Justice Institute on, to now how do we advise and support getting those funds out the door, building local capacity for those, removing barriers for locals that are looking at taking on some of those funds. What can we do there better? And it also looks at the Children's Commission's ongoing relationship, supporting the staffing of that entity. So more of that coming up, but looking at how we can be more efficient, remove points of duplication there, streamline things together, and kind of get more reintegrated into the SISC model with that youth justice component. Again, so that one's gone 95% of its journey, and we hope we have a good hearing tomorrow on 1098 for that. Other bills we're following, the large bill on chronic absenteeism, Senate Bill 482, I think just went through education this morning as we've been sitting here. That's looking good, focusing a lot on definitions. How do we have it so everybody's talking the same talk and codifying everything the same way when they're writing down all their attendance reports? If we don't have good data, we can't compare, we can't get strategies on the ground. And DOE will be a big part of doing that and developing some of the best practices for addressing absenteeism. So Senator Donato's been working a ton on that. It's kind of the next phase of what she started with the last session's House or Senate Bill 282. One more item, funding for family recovery courts. 1107 was a bill that was establishing a fund, not new funding, but a fund that would house anything that came in to help with family recovery courts, which would include also the new safe baby courts that were addressed last session. That language is no longer in 1107, but never fear, it is now amended over into House Bill 1144, which is talking about judicial officers and some other things. That part we don't have a direct role in. There's a lot of sorting hat stuff that has to go on there. The locals are talking about what their needs are, but for creating that family recovery court fund, that language is now over into House Bill 1144. So just watching for that piece, hopefully to stay intact over there. We've also continued discussion on court-appointed counsel for certain minors. House Bill 1485 was the vehicle for that this year. It did not end up moving forward, but we've reached out to the authors of that and been talking with our lived experience youth as well and saying, let's find the path forward to make sure that those youth that are at greatest need for having a more comprehensive form of representation, which might be an attorney. How do we get that moving forward? How do we get the right players at the table together and find a way that we can mediate that discussion a little bit better? So I think the commission's a great place to have some of that discussion focused and find what the path forward might look like. So we'll be continuing that in the coming years. The larger bill on juvenile law, House Bill 1605 has gone through both its chambers. It's on the final stages of concurring. It looks like that one will go through. There's been a lot of amending and things back and forth. So I'm not going to comment further on that one until we get a final version. That will probably be one that we can cover at our next meeting because I think it is a substantial piece of legislation about the process for youth going through the system. Goals of reducing time to permanency, they're certainly very noble, and we want to make sure we can be a part of however that goes forward. So that one's moved along quite well. And we think that's going to be just as it gets through concurrence, maybe a couple more little tweaks at the end of the day. Those are the main ones I've been following and working on. I know we're getting towards the end of our time. Anybody else have any other legislative items they wanted to bring forward or discuss or have questions on?
My 1241 is somewhere.
Well, 41 is somewhere. Okay.
Trauma-informed care.
Yep. And I know I got some side discussion on that. Of course, trauma-informed care, we have had a trauma and resilience committee under the commission before. So that's also, if legislatively something doesn't happen, there's things we can look at. Yeah. Yeah.
I'm a Democrat.
But yeah, I'm sure there's gonna be a point where that discussion can happen.
So real quick, I guess, two things. The commission that we have and the task force that we have dealing with bullying and teen suicide. I know we've created a committee. Have they met or how often are they planning? Do we have any guidelines or what their
Yeah.
outlook might be on that? Because I know we've had some legislation that dealt with teen bullying this year. And some of it got put in pieces and parts, and I was just curious to see what we're doing as a commission.
Yeah, that committee has been fully formed. We've got our subcommittee chairs and everything structured on that. They've had a couple of meetings under their belt now. Participation's been very, very good at that one. So we're happy to see that. Now, as we get outside of legislative session, I think the exact legislative pieces you're talking about would be good ones to sink their teeth into and look at how can we make that into something that works, that can move forward, that is maybe less piecemeal. And also hopefully 1098 goes through, we'll have additional support. That would be an example of a task force that would get that direct attention from that new coordinator.
So, and I know the DOE, have they been engaged with that so far? Do you know?
Yes, they've been very highly engaged.
I
in it.
noticed they've been absent here lately and I didn't know from our commission and I didn't know how much engaged they were.
Yeah, and I know we've had some transition and turnover with DOE, just like others, and Dr. Jenner's got a very busy schedule, but I would say DOE is probably one of the most engaged agencies that we have across the commission at that task force and committee level.
It's good to
So
know,
they're very
'cause
present.
We haven't seen them here and they've been a little bit of a roadblock for the teen bullying and suicide. But I know we put a lot on our Department of Education as far as our teachers and administrators, but it's one of the biggest, it's the number one. Suicide is the number one reason for teen suicide, for deaths.
Yeah.
In the nation. So I just feel like it's a high priority that we really need to
Yeah.
focus on.
And they've been a strong part of that discussion. And the Division of Mental Health and Addiction has also been, they've gone through some shuffling, but I think they've landed smoothly now too. They're going to be a bigger part of that discussion moving forward. So it's not an area where we love to have a lot of patience on because we want to get on the ground and get doing things as quickly as we can. But I can say it's in good shape and I think it's going to be getting in much better shape in the coming months now that we can pay a lot more direct attention.
Any questions for Mark? We have a few minutes left, so any committee member updates, announcements, questions? All right. do
This
we
is
have a motion
Senator
to adjourn?
Jackson. Hi, everybody. I think you all did a great job today. If there's anybody or any families that need assistance, resources, or employment for your clients, I'm hosting my annual job fair tomorrow, April 10th at 5:30 at Turning Point in their gym, and that's at 4501 North Post Road here in Marion County. Great employers for youth as well. So if you have youth and adult clients, 14 and over, we have training opportunities, internship, employment, full-time, part-time, summer employment, those for college students, for teachers, and and for our base that we serve here on in this call. So we're trying to provide those resource services as well for wraparound and supportive services. If you have questions, you can call 317-890-9817. Thank you so much, and you all did an amazing report out today.
Wonderful. Thank you, Senator Jackson. Anyone else? Do I hear a motion to adjourn?
Sure.
So move.
Motion and second. I will show we are adjourned. Thank you.